What liability risks do mutual aid agreements cover for firefighters? Imagine responding to a fire in a neighboring town, knowing that your team is protected no matter what happens. That's the power of mutual aid agreements. They set up clear rules so everyone knows who's responsible if something goes wrong. When firefighters from different departments team up, these agreements spell out liability protections and insurance needs. They make sure that if someone gets injured or property is damaged, the right party handles the costs. During a response, the commanding officer from the receiving department stays in charge, making decisions and directing operations. This keeps responsibility clear and helps prevent confusion about who's accountable for what. If a firefighter gets hurt while working, their home department's workers' compensation insurance usually covers their medical bills and lost wages. But if a firefighter volunteers individually, the receiving department might need to step in and provide coverage. General liability insurance is also important. Most municipalities carry policies with at least $1 million in coverage. These policies protect against claims of injury or property damage caused during the emergency. Firefighters have the same legal protections they would have in their own jurisdiction. They cannot be personally sued for actions taken in good faith during their duties. Instead, the municipality or fire district is responsible for any negligence. Many agreements include hold harmless clauses. These say that the requesting department agrees not to sue the assisting department if injuries or damage happen during the response. This encourages departments to help each other without fear of legal trouble. Errors and omissions insurance is another layer of protection. It covers mistakes made during decision-making or procedural errors. Since emergency situations often involve rapid decisions, this insurance helps protect officers and firefighters from claims related to their judgment. Equipment and apparatus used during responses are also covered. Departments maintain insurance on their vehicles and tools, and agreements often specify that the providing department is not liable for damage to equipment during the operation. When firefighters participate in cooperative programs or work on engines from other departments, the host department's workers' compensation covers injuries. Liability for third-party injuries or property damage is also addressed. Usually, the requesting department agrees to defend and pay for any legal claims from civilians hurt or whose property is damaged. To keep everything in order, departments must provide annual proof of insurance. This ensures coverage is always active and adequate. If a department wants to withdraw from an agreement, they usually need to give advance notice, often around 60 days. This way, firefighters are protected even if a department leaves the partnership. When mutual aid involves federal property or government agencies, special waivers are often included. These waive certain claims but do not affect workers' compensation coverage. Liability rules can vary from state to state. For example, in New York, volunteer firefighters responding to other jurisdictions are covered through the accepting department's insurance. In Maryland, agreements involving federal property include specific waivers for equipment and injury claims. Overall, these agreements give firefighters peace of mind. They know that if something unexpected happens during a response, the legal and financial responsibilities are already sorted out. This clarity allows firefighters to focus on saving lives and protecting property, knowing they are protected from unnecessary liability.